Anyway, we fought the subpoena in court, and Judge Hogan ruled without much fanfare that we had to go ahead and testify, and I was put in contempt of court in August of 2004. Now, some other journalists have been caught up in this net of subpoenas at this point. A Washington Post reporter named Glenn Kessler had gone in and testified that he basically had no conversations about Valerie Plame and went forward and testified as such. Tim Russert of NBC News was my co-contemnor for a while, but then he made arrangements to testify before the special counsel. So I found myself on my own being put in contempt of court in 2004. And we decided at Time Inc. and myself to ask Louis Libby if he would waive confidentiality. And if he would allow me to go ahead and testify. And I reached out to him personally in August of 2004, and then our lawyers followed up. And that was Floyd Abrams and his lawyer, Joseph Tate, at Deckert in Philadelphia. And I went ahead and testified in August 2004. And right after I testified at Floyd Abrams' Washington office, the contempt citation was lifted, and I thought I was out of legal trouble. But a couple of days later, we got a call from the special counsel, and he said, "Look, we still have a lot of questions. It's clear from your having done this deposition that Mr. Libby was not the first person to tell you about Valerie Plame having been involved in dispatching her husband to Africa. We want to know the whole story. So we're basically going to subpoena you now for all your sources, all your notes related to these stories." Well, this put us in a even more difficult predicament, because we were now faced with the question of how to react to this subpoena. And once again, we decided to fight it. This time, we found ourselves with another reporter, Judith Miller at the New York Times, facing a similar set of circumstances. And we went back before Judge Thomas Hogan. Our cases joined, and he once again didn't take long to rule that we had indeed no rights under Brandsburg to avoid a grand jury subpoena. So then we took it to the D.C. Circuit Court of Appeals before a three-judge panel of Judge David Santel and David Tatel and Judge Susan Anderson. And I believe the technical term is they laughed at us. I believe that's the term you use in the judiciary. I believe that's the scholarly term. No, they didn't entirely laugh at us. To be fair, it was a divided court panel. Judge Tatel said that he did believe that there was a kind of privilege attendant in. Now I can't remember his rationale, if it was common law, First Amendment, or a combination. Common law. One of my former counsels, Ted Boutros, reminds me. That there was a kind of privilege, but that the gravity of the case so outweighed the privilege that we had to go ahead and testify. And Henderson said you didn't really need to rule on the whole question of whether there was privilege. Santel, who'd done the most laughing in court, said there really was no privilege. And then we found ourselves desperately trying an en-banc reconsideration. That failed, and then we were on our way to the Supreme Court of the United States. And so in June of 2004, we awaited whether the Supreme Court would take our case and perhaps buy us more time. I mean, I don't think we were, frankly, terribly hopeful that the Supreme Court would take the case and dramatically rule in our favor and find a privilege so wide and broad that we need not testify. But I think our hope was to see it through. And at that point, Time Inc. and I switched counsels and tried another tack. Floyd Abrams no longer represented us, and we retained the former Solicitor General, Ted Olson, and his firm, Gibson, Dunn & Crutcher. And they put together with Ted Boutros, who's here today, and Miguel Estrada, one of their partners and a former nominee to the D.C. Circuit, a wonderful brief that argued that there was, in common law and other ways, a kind of privilege afforded to journalists that needed to be reconciled in the courts. That the court had extended privilege to social workers in the Jaffe case in the 90s, and that similar kind of questions were raised by my own circumstances. After all, in the intervening years since Brandsburg, we'd gone from just a smattering of states that had a kind of privilege for journalists to the overwhelming majority of them. I'm told the only state that doesn't have such a privilege is Wyoming, and that's really only because a case has never come up there. Well, anyway, June rolled around, and the Supreme Court, of course, declined to take the case. And so then we were all faced with difficult decisions. Myself, as one of the contemnors, Time Incorporated, because I had written that famous double super secret email, and that was very much the property of Time magazine. In fact, we determined that my notes were also the property of Time magazine because they had been taken on a Time Inc. owned computer. So Time was also a contemnor here. And then Judith Miller of the New York Times faced her own decision as well. Now, the New York Times Company was not officially a contemnor in this case because Ms. Miller had taken her notes on her own pads, and there had been determination that really, since she'd never written a story, the New York Times Company was not a contemnor here. So we all had decisions to make in June of 2004. Norman Pearlstein, my boss and friend, the head of all the Time Inc. magazines, not just Time, but Life and Sports Illustrated and 155 other titles, had to make what he's called the most difficult decision of his nearly 4 decades in journalism. And he decided to comply with the Supreme Court and turn over my notes and emails. Now, this, for most people, the decision to comply with the Supreme Court does not sound like a particularly difficult one. Even, John Lewis paid the fine, and people generally have obeyed the Supreme Court of the United States. But this is one of those major cultural differences between the journalists and if not the judiciary, maybe the rest of the country as well, which is really that there is this tradition in journalism of civil disobedience with regard to the revealing of confidential sources. And there are not many professions where thumbing your nose at a federal prosecutor is considered a badge of honor, but the Cosa Nostra and journalism is one of them. And it happened that there was a great desire among journalists for Norman Pearlstein not to do what he did. He got great opprobrium, including from the New York Times itself, which I thought was a bit unfair because the New York Times, frankly, was not in the same position as Time Inc. They were not a contemnor, and one wonders if the Times Company had defied the Supreme Court, what the New York Times' board of directors, it is family-controlled but still a public company, would have thought after a while of that. And I faced my own decision. I was quite respectful of Norm's decision. I thought it was a difficult one. I disagreed with it. I thought on balance he should have gone into civil contempt, that there were ways to push it a little bit more. But I was certainly respectful of it, and I certainly think it's more difficult for a corporation to engage in an act of civil disobedience than it is for a individual. And of course, does one really want to live in a world in which corporations, decide they don't want to obey the law? Do we want to live in a world in which General Motors says, pollution controls, we'll pay the fine. It's okay, we don't need to obey the law. And I think, it was an important question that he had to address, and he did so in a thoughtful way. I had to face my own issue about whether I was going to go to jail or not. I weighed back and forth. Many people came to me and said that I should not, including journalists. Around this time, it started to leak out that Karl Rove was my source, and so many journalists came to me and said, this is crazy. Why would you go to jail to protect a source who's essentially already been outed? This argument carried a lot of weight with me as I got closer and closer to going to federal prison. I got engaged in the world of white-collar prison consultants who tell you how to accord yourself in jail.